In 1989, a classmate was found murdered and raped. Peekskill was a small town with a population of approximately 25,000 people. Murders were very rare. So when this murder happened, it understandably it created an atmosphere of fear, of rumor, of paranoia. Parents were concerned with their own safety as well as the safety of their children. In high school, I was quiet. I was to myself. I didn't participate in very many organized sports. This made me seem strange to the kids in the school. In the course of the police investigation, the police interviewed many students from the school. Some of those students told the police that they might want to talk to me because I seemed strange to them. This is what the police said initially attracted them to me. The other factor which they claimed attracted them to me was that they said that I was overly upset at the victim having been murdered. Yet there were many mental health facilities set up all throughout the town of Peekskill to help people process what had happened, again keeping in mind that murders were very rare. They reached a point in the police investigation that they asked me to take a lie detector test. I agreed to take the test. And so the next day, rather than report to school, I instead went to the police station for a test. As I just mentioned, it was a school day, which meant that neither my mother nor my grandmother with whom I lived realized that anything was wrong, and hence they did not call around looking for me. They drove me to the town of Brewster, which is in Putnam County. I was a native of Peekskill, which was in Westchester County. The significance of my sharing that fact with you is that that meant that I was no longer able to leave on my own. I was instead dependent upon the police. They put me in a small room. I did not have an attorney present. I wasn't given anything to eat the entire time I was there. The polygraphist himself was actually a Putnam County Sheriff's investigator masquerading as a civilian. They attached me to a polygraph machine. Before they began the interrogation, I was given countless cups of coffee. The reason why that's important is that the premise of the polygraph is that when a person lies, you will become nervous. The nervousness will result in a sped up pulse rate, and it is the pulse rate which is actually measured by the machine. Other factors which will result in the pulse rate speeding up, however, would include fear and caffeine. They played the game known as good cop, bad cop, in which one officer takes on a more aggressive role while his partner pretends to somehow be morally opposed to what's going on, yet powerless to intervene. The purpose of this technique is that when the person who's being questioned becomes fearful, it is only natural that you will look to a friendly face for assistance. I was attached to the polygraph machine. Over and over again, I told the polygrapher that I was innocent and that I didn't know anything about the crime. Yet he continued his interrogation. He used all kinds of scare tactics on me. He raised his voice at me. He invaded my personal space. As the questioning grew, and as did my denials, so too did his frustration, the loudness of his voice, and his ferocity. As each hour passed, so too did my fear increase in proportion to the amount of time that had passed by. Towards the end of the interrogation, which lasted approximately 7 to 7.5 hours, he made a statement to me. He said, "What do you mean you didn't do it? You just told me through the test that you did. We just want you to verbally confirm this." When he said that to me, that really shot my fear through the roof. At that point, who should make his grand appearance other than the police officer who was pretending to be my friend? He informed me that the other officers were going to harm me, but that he was holding them off, but could not do so indefinitely. You have to help yourself here, you understand. Considering, as I just mentioned, that I maintained my innocence for the previous 7.5 hours, it was clear what he meant by that. They wanted me to confess. When it was added that if I did as they wanted, that not only would they stop what they were doing, but that I could go home afterwards, being young, naive, frightened, 16 years old, not thinking about the long-term implications, instead being concerned with my own personal safety, right then, right there, myself and the police, I took the out which they offered, and I made up a story based upon information which they had given me in the course of their interrogation. Needless to say, I was arrested. I was charged with murder and rape. By the police officer's own testimony, by the end of the interrogation, I was on the floor crying uncontrollably in what they referred to as a fetal position. Now, before I went to trial, the results of a DNA test came in from the FBI lab. Semen found in the victim did not match. Hair on the body also did not match. But rather than acknowledge they made a mistake, they instead continued to prosecute full speed ahead. In order to explain away the exculpatory DNA evidence, the prosecutor relied upon fraud from the medical examiner, an examiner with whom he was very familiar with, having engaged in similar misconduct. The medical examiner, 6 months after doing the initial autopsy, the written and recorded notes of which are taken contemporaneously, it was only 6 months after that, and after the DNA excluded me, that suddenly, for the first time, he claimed to have found medical evidence, multiple healed tearings, in the victim's vagina in order to try to open the door for the prosecutor to argue that the DNA exclusion didn't matter because she could have had consensual sex close enough to her murder and rape so as to explain away the DNA. Even going so far as to mention somebody by name who he argued by inference had this sexual encounter with the victim. Yet, he never attempted to prove that assertion. He never had a DNA test performed on this other youth that he falsely implicated, nor did he even call him as a witness to give verbal testimony to that effect. He just made the unsupported argument to the jury. At the same time, my public defender was not very good. That medical examiner, which I just referred to as the critical role he played in my conviction, when it was time for cross-examination, my lawyer stood up in open court and with a big Kool-Aid smile, as if him and the medical examiner were really good friends from way back in the day, said to him, "You're going to be pleased to know that I don't have a single question for you." My attorney never should have represented me in the first place because there was a conflict of interest, because this other youth, which the prosecutor implicated in his false argument, was simultaneously also represented by the Legal Aid Society. So we were not able to investigate him as an alternative suspect. We were not able to put him on the stand and explode the prosecutor's myth. When the hair didn't match me, the prosecutor again resorted to argument by inference rather than argument by evidence. When the hair did not match me, the prosecutor argued by inference that it could have come from that medical examiner and his assistant. Yet, unbeknownst to me, when the match was not made, the hair expert asked for hair exemplars from those two professionals, which the prosecutor never bothered to provide. My attorney was supposed to jump on that and insist that the samples be turned over and the comparison made. Yet he never did that. He never explained to the jury the significance of the DNA exclusion. He never argued that the DNA proved that the so-called confession was coerced and false. He never presented my alibi evidence. I was actually playing wiffle ball with a friend of mine when the crime was committed. He never put on the record an extrajudicial statement that the judge said to him. We had not decided what type of a trial we wanted to have, whether it was a jury trial or a bench trial. So during that period of indecision, the trial judge told my attorney off the record, "Pick a jury, because I don't want to be responsible for fully acquitting your client." He told me about that statement, but he never put that on the record. Every time I tried to explain to my attorney what had happened in the course of the police interrogation, he was always shutting me up. He never wanted to hear it. In his words, "I don't care if you're guilty or not, it's my job to defend you." He wouldn't allow me to testify at the Huntley hearing because for his reason, he hadn't decided whether I was going to testify or not at the trial, and therefore he didn't want to have me on record saying anything about the circumstances under which this confession was obtained. Which really doesn't make sense because if in that case, if you can get the statement suppressed as being involuntary, there is no trial. And then when I got to trial, he wouldn't allow me to testify there either. His reasons? His personal one-loss record was significantly better in cases in which his clients didn't testify as opposed to when they did. Now, A, that's not strategy, and B, most likely most of your clients have a record, and so your strategy there is to prevent their other convictions from coming into evidence. But I had no prior record. And his other reason for my not testifying was that he said, I don't have to prove that you're innocent, they have to prove that you're guilty. Which, although that might be a legal truism, a legal maxim, in reality, that's not true. I'll never forget the day that, add it all up together, I guess it's not that surprising that the jury found me guilty. I'll never forget the day that I was found guilty because, to my way of thinking, at least up until that point in time, only guilty people were actually found guilty. Yet the jury said what they did, and I was taken into custody. On the day of the sentencing, I begged the judge to overturn the verdict because I was innocent. I referenced the DNA to support my contention. He actually told me, on the record, maybe you are innocent. That didn't lead him to do the right thing and step up for justice by overturning the conviction, as was within his power and discretion to do so. Instead, he sentenced me to a term of 15 to life. I would like to share with you a little bit about my prison experience. I still remember the first day. I remember being in handcuffs and having a chain around my waist and having my legs fastened together as well as being fastened to the legs of the prisoner on the bus next to me. I remember how large the prison walls loomed and how menacing the barbed wire appeared. I don't mind sharing with you that I was really frightened. As I walked down the cell gallery, I saw many prisoners there whose arms were as big as my legs. It didn't take a lot of figuring out on my part to realize that if any of them decided to assault me, that I would not be able to successfully defend myself. I also had the built-in handicap of knowing that if they discovered what I was incarcerated for, which was a rape along with that murder, that this would serve as motivation on their part to assault me, because in prison there's a vigilante mentality towards people who have been convicted of sex offenses. The guards themselves were obstacles. To be sure, some of them were professional and did their job. Yet there were others who came to work and brought the frustrations of their personal life into the facility, and they displaced it onto the prisoners. Then there were other guards who even their peers despised, because the manner in which they conducted themselves on a day-to-day basis made it likely that prisoner-to-staff violence could occur, or possibly a riot could ensue. Yet nobody ever bothered to reel them in, not their co-workers, nor the people who supposedly were there to oversee them. Then there were other guards who just wanted to do their 8 hours and go home, and they didn't care what happened while they were there. While that might sound like an ideal attitude that you would want a guard to have if you had to be incarcerated, it didn't actually work out that way in real life, because it would not be unusual for them to literally look the other way and walk in the opposite direction when violence was occurring, so as to be able to get out of having to break things up and file paperwork afterwards. In the facility in which I spent 13 and a half of the 16 years, Elmira, it was particularly violent there. There were 3 or 4 stabbings or cuttings every day. There was no shortage of other violence that did not involve weapons. And there was plenty of gang activity, which, taken in combination, led to this general pervasive atmosphere of violence in which you had to watch your back at all times, including when you were in your cell. There was a system of discipline employed by the Department of Corrections known as keep lock, which involved a variety of sanctions being imposed on the prisoners if they were found guilty of having committed broken a prison rule. Those sanctions included, but was not limited to, being kept in the cell 23 hours a day out of the 24, of being able to take 2 showers one week and 3 the next, as opposed to being able to shower daily. They would send you less food. Sometimes the food they sent you would be 3 days old. Their idea of complying with the court-mandated 1 hour a day recreation consisted of putting the prisoners in a small caged area with maybe a pull-up bar in it if you were lucky. You would not be able to call your friends or your family while you were on such status. There were several times in my incarceration in which I was assaulted, and one time in which I nearly lost my life. In addition to dealing with that physicality, I was also subjected to those sanctions, because in prison, if you're defending yourself, then you were fighting. While I was in prison, I tried to minimize the loss that I was experiencing. I obtained a GED, I obtained an associate's in liberal arts, and I completed a year of further schooling towards a bachelor's degree. But then even this silver lining was taken from me, because in 1995, George Pataki became governor, and he decided it would be a good idea to cut the funding of college education towards prisoners. When that happened, I turned to the vocational shops that were available in the facility. But although I completed many different trades and amassed many a certificate, it looks much better on paper than what it is in reality, because much of the material was obsolete 5 years prior to my ever having set foot in the vocational shop. I read many books, nonfiction books, in the general library, but it always seemed that they looked for the slightest excuse so as to be able to cancel the library for that particular night. In 1996, I got a phone call from, the doctors in the hospital called the facility, and in turn, one of the prison employees contacted me, and they informed me that my grandmother was in the hospital and that she was not going to make it, and therefore I had a choice. Did I want to wait until she passed away and then go to the funeral service, or did I want to see her one last time while she was still alive, albeit in a coma? I didn't really understand what the purpose of my having to make a choice. Would it really kill them for me to be able to go to both? Yet that wasn't how the system worked, and I had to make a choice quickly. Not lost on me was the fact that there were many members of my extended family who had never made the trip to see me in prison, and who would never make the trip to see me while I was in prison. And given the uncertainty of the outcome of my case, this represented the last clear opportunity for me to see some of them. So as you might imagine, it was a very difficult position to be in. In the end, I decided that I would like to go see her one last time while she was alive, albeit in a coma. We left the facility early in the morning prior to the population having been served breakfast. I've always suffered from motion sickness, and one of the ways you protect yourself from getting sick from motion sickness is eat prior to going on the journey. As I mentioned, we left early in the morning prior to the population being served breakfast. The guards were given funds with which to purchase food items for themselves as well as for me. But although they got something to eat for them, I was simply given a cup of coffee. There were several times on the trip that they had to stop the car because I was on the verge of vomiting. Yet, because nothing was put in my stomach, nothing came out. I guess I was lucky that I hadn't been given a quantity of food, however small, because had I gotten any of it on me, either on my clothes or on my face, I would not have been able to wipe it off, considering that I was in handcuffs and had a chain around my waist, and they were unwilling to loosen it even a fraction of an inch, despite the fact that there were two of them and both of them had sidearms and that I was in manacles and surely could pose no threat to them in that state. When we finally got to the hospital, they parked the car as far away from the hospital doors as they possibly could so as to be able to parade me through the parking lot. Again, keeping in mind that I had on handcuffs and a chain around my waist and had my legs fastened together as well. I remember as I walked through the hospital doors, the nurse attendant did a double take at the sight of me. And there was a child running around who could have been no more than 5 or 6, who, once their mother got one look at me, grabbed the child really fast, pulled the child to her, as if I was some sort of violent animal that was going to commit a spontaneous act of violence right there on the spot. It was definitely a humiliating situation. At the end of the visit, the guards came into the room where I was with my grandmother, and they informed me that my hour had been up. I looked up at the clock, and I saw that in point of fact, it had only been 45 minutes. But they insisted that the hour that had been up, and they made me leave, again parading me through the hospital corridors and the parking lot. Unlike the trip down, this time I was given something to eat. However, the parking spot where the car had been parked, it lent itself to the sunlight kind of beaming through the windshield. And so 45 minutes later, the car had become quite hot. Although the guards turned on the air condition, none of it reached me since there was plexiglass completely walling off the front of the vehicle from the back, and they were unwilling to lower the window even a fraction of an inch. All told, I suffered for between 8 to 9 hours in order to visit with my grandmother for less than 1 hour. I have a brother who's 3.5 years younger than I am, and he too was impacted by my wrongful conviction. The kids in school and on the school bus used to tell him that his brother was a murderer and that he was a rapist, and they used to call me other names to him, and they used to try to hit him and stab him with pencils. I guess being unable to get to me, he was the next best thing. Give me a second. Eventually, he dropped out of school and has never returned to this date. When it started off, my mother would make the 3.5 to 4.5 hour trip about twice a month, because the Department of Corrections is in the habit of initially housing prisoners who are from the city in the facilities that are far in northern New York, and housing the prisoners in northern New York in the facilities that are near the city. So when I first got started with my sentence, as I mentioned, my mother used to make the trip once or twice a month. But as the years wore on, and I imagine the long travel grated on her, and she developed a few health issues, and her economic situation tightened up a bit, I began to see her less and less until eventually I was lucky if I saw her once every 6 months. Towards the end of my prison minimum, the authorities informed me that if I wanted to have any chance at all at making parole, which was already a slimmer than slim possibility, that I would have to take and complete the sex offender training program. The problem with my completing that class, however, was that there was an explicit guilt admission requirement. I would be required to admit guilt not simply to the instructor, but also to the other prisoners that were in the shop with me. A verbal rendition would not suffice. I would have to put it in writing. Simply saying I was guilty would not suffice, even in writing. I would have to write down all of the details. Failure to do any of those things would result in my automatic removal from the program, and I would be deemed to have refused to complete the class. Now, at this point, I was looking at parole as a potential means of regaining my freedom, and certainly I wanted to do so before anyone else in my family passed away. So once again, I was confronted with a very difficult catch-22 situation. In the end, after a lot of soul-searching, I decided that I would not take the program. I couldn't bring myself to say that I had done things which I know that I hadn't. When I went to the parole board, I kept repeatedly raising the issue of my innocence and citing the DNA, because I knew that the parole board was in the habit of rubber stamp denying applications even from meritorious applicants if they had been convicted of a violent crime. And so to try to protect myself, I kept raising the issue of innocence. But they were unwilling to consider that even as a possibility. Towards the end of the parole interview, one of the commissioners asked me a question about an aggression replacement training class, and I was able to give him the answer, demonstrating that I had learned the material. That's when another commissioner piped up and said, "Well, that's good, Mr. Deskovic. You're going to need those skills once you return back to society. Good luck." The process is that they don't inform you of the decision right there in the spot, but instead it is mailed to the prisoner 3 days later. Considering how the interview ended, I actually walked around the prison for the next 3 days thinking that I had somehow defied the odds and that I would be going home. Instead, when I got the decision in the mail, it informed me that I had done a good job with respect to completing educational programs, that I had a very good educational record, that I had a few letters of support, that I even had a letter of support urging my parole from a prison employee, but that nonetheless I had been convicted of a brutal and senseless crime, and to release me would be to deprecate its seriousness. They ordered a 2-year hold. Now at that point, considering that I knew many people who were working on years 25 and 30 off of a 15 to life sentence, in which they would go to the parole board, be denied, reappear 2 years, be denied again, and have that cycle continue in seeming perpetuity, knowing their fate and knowing what just had happened to me, I thought that I was going to die in there. I would like to share with you how it was that I came to be cleared. While all this was happening, and a lot more that I'm skipping over just for the sake of time, I was simultaneously appealing my case throughout the court system. I went to the appellate division, which is the first court one must go to. My primary issues on appeal were, number one, my innocence as established by the DNA. My lawyer made reasonable doubt arguments, weight of the evidence arguments, and legal sufficiency arguments. Another argument was that my Fifth Amendment rights had been violated by the manner in which the police had questioned me. In addition to those 4 arguments, there were also 6 other solid points of law, which I'm not going to go into now because it's largely irrelevant to the main thing I want to talk about today. When I got the decision from the appellate division, they found nothing wrong with the way that I'd been questioned. Furthermore, they ruled that there was overwhelming evidence of guilt, which really makes no sense because all the forensics in the case were on my behalf. They ruled against me 5 to nothing. My lawyer moved to re-argue the case in front of that court, arguing that their decision was running contrary to the facts and to the law, but the re-argument motion was denied. I then went to the Court of Appeals, New York State's highest court. The procedure is that you first have to obtain permission from the court before they will agree to hear the merits of your case. The Court of Appeals told me that there was no merit in law to justify reviewing my case, and so therefore they were not going to review it. I then looked to the federal court for relief. I filed a petition for writ of habeas corpus, which is when a state prisoner is arguing that his or her conviction is running contrary to the United States Constitution. Again, my primary arguments were my innocence as established by the DNA and my Fifth Amendment rights. Now, at that time, there was confusion in the federal court system because 1 year prior, Congress had passed and the President had signed into law the Anti-Terrorism Effective Death Penalty Act, which in relevant part stated that all state prisoners would have 1 year to file in federal court after being denied by their state's highest court. The confusion in the court system centered around how would this new law apply to cases that were already in the system, and different jurisdictions were answering the questions differently. My lawyer, therefore, called the court clerk and asked, would it be sufficient that my petition be postmarked on the due date, or did it have to be physically filed and in the building on the due date? The court clerk told my attorney that it would suffice that my petition be postmarked. Well, unfortunately, that information turned out to be false, and as a result of that, my petition arrived 4 days too late. former Westchester County District Attorney and New York State Attorney General candidate Jeanine Pirro, her office urged the court to simply ignore the issues that I was raising and simply rule that I was late, and that would be that. And the court chose to adopt the position urged by the district attorney. That meant that I was time barred. So now I was no longer able to argue my issues directly. Instead, I was reduced to having to argue that the procedural ruling against me was inaccurate in order to have that reversed, to then have the original federal court rule upon the merits of the issues. So I went to the Federal Court of Appeals, and much like the New York State Court of Appeals, one must get permission from them before they'll agree to hear the merits of what you're appealing. I applied for permission, and I was granted permission. The two judges sitting on the panel were Rosemary Pooler and United States Supreme Court Justice Sonia Sotomayor. My lawyer advanced 3 arguments as to why she should reverse the procedural ruling against me. One of them was that to uphold a decision such as that would be to cause a miscarriage of justice to continue, which is kind of like backdooring my innocence argument, at least as a contextual issue. The next was that this was not a delay caused either by my own misconduct or something I did wrong or by my attorney, but instead was caused by the court clerk. And another argument that was advanced was that reversing the procedural ruling against me would open the door to more sophisticated DNA testing. Once again, the district attorney opposed, and once again, the court sided with the district attorney. My lawyer then moved to re-argue the case in front of those same 2 judges, in fact, requesting that all the judges on the circuit hear and rule on the issues. That's how strongly she felt about them. Yet, once again, I was denied. That meant I had one court left to go to, the United States Supreme Court. Nationwide, that court agrees to hear only between 2 to 5% of the total number of issues that come in front of it. Included within that paltry figure is a certain amount of civil matters. So we knew going in that the odds of them agreeing to review my case, despite compelling reasons of justice as to why they should do so, were slim. Yet, having no other court left to go to, I had no choice but to forge ahead. I was not able to overcome the odds. As expected, the United States Supreme Court declined to give me permission to appeal to them. That marked the end of my appeals. That marked the end of legal representation. That was in 2001. The path at that point to clear my name, overturn the conviction, and therefore regain my freedom was that I would first have to somehow obtain an attorney who would be willing to work for free, for neither I nor my family had any funds with which to hire one. Then I would have to find an investigator who would work on a similar basis, and that hope that in collaboration they could somehow find some additional evidence of innocence without which the courts were no longer willing to hear from me. Or at the very least, they would have to uncover some new facts that would open up previously unavailable legal arguments, or maybe that some retroactive change in the law would occur. Without either of those 3, I would simply be stuck in prison without the courts willing to entertain any of my challenges. So my legal work at that point, if you really want to consider it that, consisted of writing SOS-type letters to anyone and everyone I could possibly think of who could be of assistance to me, either directly or indirectly. I wrote big law firms because I had read in other wrongful conviction cases that such firms often have a pro bono section in it, and that some people had obtained legal representation and ultimately were exonerated. But I very rarely heard back from them. When I would hear back from them, they would tell me that they didn't have any time to take my case for free. Although they always managed, before those letters concluded, to tell me exactly how much money they would want should I somehow be able to scrape it together. I guess what they were really saying was that if I had the money, then they had the time. Then they would end the letter by saying good luck, as if somehow I would be okay despite non-intervention. I wrote reporters, especially those who had written on other wrongful conviction issues. Maybe their general familiarity with the subject matter would lead them to understand what I was saying. After all, how many prisoners could write them and tell them that there was a pre-existing DNA exclusion? Maybe that would pique their interest, and they would poke around a bit and write an article or two, and the end result of that would be that I would obtain legal representation, my case having come to the attention of one of those two professionals that I mentioned, either the lawyer or investigator. Only I never heard back from any of them. I wrote faith-based organizations, reasoning that their belief in God, in whatever form or faith that might take, would cause them to be against injustice and therefore in favor of justice, and by extension, in my behalf. Perhaps they would be willing to raise the funds for me so that I could obtain the necessary legal services. Or perhaps a parishioner of theirs was an investigator or an attorney that they could somehow prevail upon. Only I never heard back from any of them. I wrote not-for-profit organizations that do successfully clear wrongfully convicted prisoners. The problem I ran into there, however, was that the amount of resources available to those organizations, the number of organizations, and the number of people vying for their assistance, there was a great disparity. And so I guess in the eyes of the evaluators, I was unable to beat out the other cases in that cruel competition. In 2005, I had a chance encounter in the mail with an investigator who worked out of Colorado and Maine, and who also worked against the death penalty on a federal level. I was actually writing a book author who had penned her memoirs from when she was a warden from a men's maximum security prison in California, and an excerpt of that book made it into another book which had excerpts from many different books. And so, having read the credits and further byline, if you will, of the authors, I decided that this author would be somebody who I'd like to write, because perhaps in the course of her walk of life, she would have come across somebody who could have been of assistance to me. So I wrote her, but she never received the letter. Instead, somebody at the book publishing company read the letter and sent it to the investigator. The investigator wrote me back immediately. She gave me ideas, we brainstormed together, and she attempted to get places to take my case. One of the ideas she gave me was that I should write the Innocence Project again, a not-for-profit organization out of Manhattan that works to clear wrongfully convicted prisoners across the country in those cases in which DNA testing can demonstrate innocence and in which no prior testing had been conducted. The reason why I say again is because I originally wrote them back in 1992-93. DNA was not as sophisticated then as it's come to be now, and so the cases that they took on were of that criteria that I just mentioned. The investigator informed me that given the advancement in technology, that the prior denials from the Innocence Project were irrelevant, and therefore I should write again. Now, I had obviously been keeping up with DNA for obvious reasons, but I would not have thought to write them a second time, reasoning that I would get a similar response the next time. But I was out of moves. I didn't have any more options, and so I wrote them. They sent me a questionnaire, which I filled out, and then I forgot about it. I continued to look for other ways of obtaining legal representation, none of which were successful. 6 months later, seemingly out of the blue, the Innocence Project wrote me back. They informed me that they were going to take my case. They convinced the district attorney, who by now was a different district attorney, Ms. Pirro having left office, and the new DA had been in office for a mere 40 days. So they approached her and got her to voluntarily agree to allow me to have further DNA testing. They took the crime scene DNA evidence, which already didn't match, and ran it through the DNA database, which contained samples of people who either were currently incarcerated for violent crimes or who were incarcerated for, or whose DNA was in the data bank as a result of their having previously been incarcerated for violent crimes. The results matched that of a man who left free, killed another woman 3.5 years later after he committed the crime for which I spent the 16 years in prison. Confronted with the evidence, he admitted that he was the person who had committed the crime. On September 20th, 2006, my conviction was overturned and I was released. I reported back to court November 2nd, 2006, at which point all of the charges against me were dismissed on the grounds of actual innocence. I received an acknowledgement of my innocence and an apology both from the judge and from the district attorney, although neither of them were the counterparts who had anything to do with my conviction in the first place. At that point, I was released free and clear with nothing more than the suit that I had on in order to somehow rebuild my life. I would like to share with you a bit about what my life's been like since I've been released. When we read about exonerations in the newspaper, we generally have two thoughts. One, we're horrified at the injustice having occurred, and secondly, there's a type of joy that we experience that at least the person's suffering is over. And we believe that it's a happily ever after. Unfortunately, the reality is anything but that. For someone who's been wrongfully convicted, you've simply left one set of problems for another. I was released with nothing, as I mentioned to you. It took me about 2 years before I was able to find stable housing, moving from place to place, at one point nearly ending up in a homeless shelter. The world was much different than when it was when I was originally incarcerated. Some concrete examples would include there was no internet, we didn't have GPSs, the sophisticated methods of banking that we employ every day were unheard of, and we didn't have cell phones. As I walk down the streets of towns and cities that I once knew when I was a youth, I feel like I'm in an alternative world, because although some of the buildings and structures remain there, many others are absent and are replaced with others. The people who I once knew inhabited those towns and cities have long since moved on. When I visit with my extended family in order to reestablish relations with them, keeping in mind that the majority of them never visited me, and the few that did would come to see me, and then I wouldn't see them for another 2-3 years. Then they'd disappear, and I'd see them again 3 years later, so on and so forth. It's an awkward experience because even though I know who they are intellectually, and I have memories of them from when I was a youth, when you spend that much time away from people, you don't know who they are as people anymore, nor do they understand who I am as a person. I see a counselor once a week in order to assist me in readjusting back into society and into trying to understand the world out here more. There's some good things that I'd like to impart also as part of my reintegration. I received a scholarship, a full scholarship from Mercy College, which I availed myself of and completed the 30 credits for the bachelor's degree. I have the master's degree pending right now. I've become an advocate, as was mentioned before. I'm not going to give a rundown of the stats. I just thought that was important because when I get into some of the policy things in a minute, I just wanted it to be clear that I'm not basing things solely on my experience, but that, you know, I've read and I've studied, and to some extent I'm an academician as well. I find that the advocacy work I do is the vehicle which enables me not to be bitter, because I can take that energy and I channel it into that. I believe I'm here for the purpose of battling wrongful convictions. That's the only way I can make any sense out of what happened to me. And so I'm trying to make a difference in the ways in which that were mentioned and in starting the foundation. The Jeffrey Deskovic Foundation for Justice has 4 prongs. We seek to raise public awareness because that paves the way for needed legislative changes. We seek to obtain legislative changes in order to prevent wrongful convictions from happening in the first place. We seek to clear people, not simply in DNA cases, as many of the organizations, including the Innocence Project, limit themselves to, but also in non-DNA cases. To me, the idea that someone is wrongfully convicted, they're incarcerated, and they have to remain incarcerated simply because of the fact that they have no one to turn to do the boots-on-the-ground investigative work needed to enable them to clear their name and therefore regain their freedom is unacceptable to me. And that's why we do non-DNA cases as well as DNA cases. We try to help people reintegrate back into society, realizing that it's not enough simply to clear somebody and then leave them on their own, but they need assistance in picking up the pieces and putting back together a life. I mentioned legislative changes, and I want to go over what the systemic deficiencies are that lead to wrongful convictions, as well as what the needed reforms are in order to shore up those cracks in the justice system which enable innocent people to fall through. We need better identification procedures. Misidentification has been the cause of wrongful convictions in 75% of the now, it's 290 something, I forgot the number. Somebody was just exonerated the other day in Texas through DNA after 24 years on a rape case. So the number's into the 290s. All the statistics I'm going to give are in reference to the DNA exonerations. There's like triple the amount of exonerations in non-DNA cases. It's just there's no real centralized place which has all the cases listed. We need to videotape interrogations from beginning to end, which would enable there to be a complete and accurate record. Who said what, when, and in what context? Is a suspect truly volunteering non-public facts, which only the perpetrator would know? Or are they simply being fed details that they're then incorporated into their answers? Or are they given simply yes and no answers? It's important that the videotaping take place from the beginning to the ending, rather than at some point during the interview, for who knows what goes on prior to the camera rolling. And it shouldn't be, a trial shouldn't be reduced to a swearing contest between a suspect and a police officer. For how many times is a jury going to rule in favor of a suspect over a police officer if they omit details and change their testimony as from what really actually happened? We need to have safeguards with respect to incentivized witnessing. Incentivized witnessing is when a witness receives an incentive, a reward, in exchange for testimony, whether financial, whether having charges dismissed against them or not prosecuted, or receiving a lesser prison sentence. That's been the cause of wrongful convictions in 15% of the 290-something DNA exonerations. Some of the protocols in this area would include wearing a wire, a transmission device that would then sends the conversation to a recording device so that we can be sure that these dubious jailhouse confessions in which men who've met each other for a simple matter of months, and in some cases less, that they feel free to admit that they've committed serious crimes. So that we can be sure that these conversations actually take place rather than being fabricated. Because when a prisoner has been caught red-handed committing a serious crime and they don't have any truthful information on which to trade, they will result to falsely incriminating other people. And I want to add, the reason why all the statistics add up to more than 100% is because frequently there's more than one cause of wrongful conviction. We need to criminalize clear-cut, intentional prosecutorial misconduct. When prosecutors engage in conduct such as withholding exculpatory evidence, suborning perjury, not correcting perjured testimony, working hand in glove with experts, tell me what you want to prove and I'll prove it, they've in effect pulled off illegal kidnapping under the color of the law. As such, it should be punished, not just to punish wrong conduct, but as a deterrence. Currently, there's no deterrence in place. Not only is there no criminal deterrence, but there also is no civil deterrence either. In the U.S. Supreme Court decision, Thompson v. Connick, the Supreme Court narrowed so severely the ability to sue the prosecutor. You already can't sue the individual prosecutor for anything that they do once an arrest has happened is deemed to have been done as an advocate, and therefore they have total immunity. But now, as a result of Thompson v. Connick, it's almost impossible to sue the office as a whole. So given both of these things, there is no deterrence. We need to remove both. Why is it that prosecutors need to be considered a special class of people immune from redress on their actions? There's no other facet of law enforcement, not a correction officer, not a police officer, not a defense attorney. They don't have those immunities. They're not restrained from doing their jobs. If you don't want to be sued, if you don't want to be prosecuted, do one thing. Don't violate anybody's rights. Follow the law yourself. We need to have a standardized evidence preservation system. In New York State, as well as many other states, if you're lucky enough that your case even falls within that 10 to 12% that has DNA in it to test, the first obstacle you have to overcome is whether or not that evidence has been lost or destroyed. If either of those has occurred, you would simply be stuck in prison, unable to prove your innocence. I've always considered the death penalty to be a wrongful conviction issue, one of the most important reform, because of the obvious risk of executing somebody who's innocent. When I look at my case and I think about, what if New York State had a death penalty statute on the books? What if I was 2 years older and everything else played out exactly the same? Well, let's look at what makes a case a capital as opposed to non-capital, and let's see whether those factors are present. Well, it was a community outrage, which is one of the factors. I was convicted of a rape along with that murder. That's often an aggravating circumstance, and it was a brutal crime. So I would have qualified. My appeals ran out in 2001, and I wasn't exonerated until 2006. So I wouldn't have been alive in order to have been exonerated, and I certainly wouldn't be here speaking in front of you this evening. We need to have immediate assistance for people who've been exonerated. Now, I know the parole system is very flawed. I agreed completely with Mr. Hammack. I gave my own comments. That being, and I know that the parole system, whether release or the supervisory, it has many things wrong with it. That being said, there is still something out there for people on parole. There is nothing out there for exonerees. As I stand here before you tonight, had I been guilty and paroled, I would have received more assistance from the state than what I did as an innocent man. Lawsuits typically take between 3 to 5 years to resolve, sometimes longer. There is no safety net. As one tries to grapple with a new world you don't fully understand, deal with emotional trauma, while all these financial burdens come at you right away. I'd like to equip everybody, as I wind my presentation down, with some tools that we all can do. We all have different stations of life. We have different spheres of influence. We're of different financial means. We have different careers. Yet there is something that all of us can do. Can you write letters to your elected officials? Can you let them know that the criminal justice system as it's currently constructed is broken and that it's unacceptable to you? That although the causes of wrongful conviction are well known and documented, and although New York is third in the nation with exonerations at 27, not a single reform has as yet been passed. Can you write them a letter just one time to tell them that it's unacceptable? Can you sign a petition when they come around? Can you attend wrongful conviction events when they happen? Can we encourage other people to do so? Can you be an agent of change to help grow the movement? Can you learn about wrongful conviction causes and reforms and share that knowledge with our friends and family? Can we challenge officials who are running for office to insert wrongful convictions as a policy issue, as I had the opportunity to do in 2009 in the midst of the Manhattan District Attorney Office? By the time the race was finished, all three candidates were vying with each other about who was going to do the most to not only undo pre-existing wrongful convictions, but who was going to prevent future wrongful convictions, who would go the furthest. Although the candidate I backed didn't win, we furthered the issue tremendously. That's a tactic that we need to adopt. To coordinate conferences such as these and other events, it doesn't suddenly come about. There's a lot of behind-the-scenes work that takes place. Can you find it within your schedule to volunteer for a few hours? Can we put together, for those of us who have organizing skills, can we organize an infrastructure in each geographical area, from state to state, from county to county, from city to city, from town to town? Can we back advocacy work with grassroots work? How about 3 people go and speak to an elected official about a reform, and meanwhile we had several hundred, if not several thousand people first participate in a march and then park themselves outside of the office? Politicians rarely do things because it's the right thing to do politically. It almost never happens that way. It's only when change is linked to votes, to voter unrest, to getting elected, to getting campaign donations, that change happens. So long as they're convinced that the current status quo is okay with you and I, nothing is going to change. Despite my efforts, despite the efforts of many talented people in this room and in beyond these walls who couldn't make it, nothing's going to change until the average person is aware and no longer considers it acceptable. Another way we can all support the work is financially. We're all of different means. As an example, I've given my organization a running start. I've guaranteed 3 years in which we have to become sustainable externally. But I can't carry the organization individually indefinitely. You don't have to be wealthy to contribute. If the president, whatever you think of his politics, raised $100 million through grassroots fundraising, contributions of 10, 20, 50, that breaks nobody's budget. Can you make a contribution just one time? Are there people of means that you know of that you could just put a bug in their ear? Hey, this is what I learned at the conference. This is about this foundation or that foundation. What are you going to do for a tax break this year? Consider this for your tax write-off. Are there other organizations that you know of that might be interested in my doing a presentation? When I do presentations, I don't take the honorarium. It's made out to the organization as a minor way of fundraising. There's other places that might benefit from my doing a presentation that you could just float the idea to. That's a help as well. Again, I want to just say that if we all do a little bit, we can get a lot done. In closing, in thinking about whether this will be a memorable weekend, simply in thought, do you remember this guy, remember this person, remember this issue? Gee, he or she was a good speaker. Whether we want that to be what our weekend demarcation is, or whether we want that to mark the beginning of an additional awareness, an additional piece of information, which we then act on in our lives to the extent that we can. Consider this. I had never been arrested for so much as a violation. I was not a high school dropout. In fact, I was on my way to school when I was initially intercepted by the police. None of my friends were involved in crime. It happened to me, and it can happen to you. Your best friend, your neighbor, your son, your daughter, your husband, the person on the seat next to you. Don't wait until you're personally affected. Act now. Thank you very much.